So the Digital Personal Data Protection Bill, which is open to public for comments until 17th December, is expected to be introduced in Parliament in the 2023 budget session. This is the fourth version of the bill released by MeitY since 2018, after the last version of the PDP bill, the last iteration, which was withdrawn in August this year, 2022. The 2022 bill applies to processing of personal data and excludes non-personal data. Unlike the previous versions, this bill is considerably narrow in scope, and provisions which initially raised concerns for the data and the tech industry have been somewhat toned down, in fact, quite a bit toned down. However, the potential impact of some personal data rights of individuals and the adequacy of checks and balances on executive powers and exemptions is yet to be seen, and we will only know with time and delegated legislation. Probir will share some more on specific amendments and how it will affect companies and consumers.
Thanks, Rupinder. Yes, you're absolutely correct. The new bill has many positives and some concern areas. I think it's good to look at the positives first. The first is the data localization concept. The government has been very vocal about its intent to dilute the data localization requirements contained in earlier versions of the bill. And as you'll notice that the new bill has done away or diluted the language concerning data localization. Of course, there is some uncertainty because Section 17 of the bill states that the government may specifically whitelist countries to which personal data may be transferred from India. Our view is that the government will only notify Section 17 once it has finalized its list of permitted countries. Therefore, this section may not be notified immediately once the bill is enacted in the Parliament. However, should Section 17 be notified, we don't believe that the government is likely to take the view that all cross-border processing would need to cease immediately until the list of approved territories is notified. In our view, the government is unlikely to take such a position given the vast amount of personal data that is currently located or processed outside India by data fiduciaries. The other positive is the exemption for Indian data processors of foreign entities. As you'll note, the bill now explicitly exempts its applicability to the processing in India of personal data of foreign data principals if such processing is conducted pursuant to a contract entered with any person outside India. This is a welcome change from the earlier versions, which required specific notification from the government in this regard. The concern area: language for notice. If you'll note, Section 6.3 of the bill requires a data fiduciary to provide the data principal the option to access the privacy notice not only in English, it says in English or any language specified in the 8th schedule of the Constitution. Section 3 also clarifies that the data principal must have the choice to select English or any one of the languages specified in the 8th schedule. What does this imply? This means the data fiduciary may need to have its privacy notice translated into 21 different languages, since the data principal may choose any one of these languages. Notably, a similar requirement has been implemented in relation to platform policies of intermediaries. This is an extremely onerous requirement and could adversely affect business in India. As a firm, we are going to go back to the government seeking clarity and raising these concerns. Last but not the least is the definition of loss. This is an interesting point which has arisen during our discussions on the bill with our clients, and that is the definition of loss and its implications on claims for indirect damages. Loss under the new bill includes an opportunity to earn remuneration or greater remuneration or to gain a financial advantage otherwise than by way of remuneration, which seems to include indirect damages to the extent of loss of opportunity remuneration. Typically, as you know, loss of opportunity or loss of future remuneration is excluded as part of indirect loss under tort laws and in private contracts. However, the bill appears to include this type of indirect laws under Section 11B, which is contrary to judicial precedent. We will again be raising these issues when submitting stakeholder feedback, which we are doing as a firm for a lot of our clients. Let's see how the bill is reviewed and how the discussions with the regulator takes place. December 17th is the right time to go back to the government, and we will be doing so. And hopefully the government will take our comments and feedback, and a revised bill will be processed and implemented in the parliament.